Morning, Your Honors. Benjamin Crawford on behalf of Mr. Corey. May it please the court, even though the Supreme Court modified Rule 1.510 back a few years ago to modify the Supreme Court standard in Florida, it still is applying that in 1.510, they retained the language, the Supreme Court retained the language requiring that a party that's moving for summary judgment must cite to record evidence to support its position.
Have you read the Supreme Court's opinion regarding the amendment to Rule 1.510?
Yes, Your Honor.
Are you familiar with the part where they explained that a moving party, like a defendant that doesn't have the burden at trial, can obtain summary judgment without disproving the movement's case? And they can do that in one way, as the court explained, by pointing out that the non-moving party lacks. We need not set forth evidence from the non-moving persuasion and can point out that the moving party lacks the evidence to prove the operative claim.
Yes, Your Honor.
So you're at this hearing and Judge Moe asks, what evidence do you have? And your response was, I don't have to produce any evidence at this time because I'm defending summary judgment. Is that consistent with what the Supreme Court has instructed with regard to the amendment?
Yes, Your Honor. And if you look at that in conjunction with the Celotex case, which is cited throughout, the case law and everything as kind of the basis of the federal standard, it talks about, and the appellee had cited in their brief, the 4 parcels of real property case. And that goes directly to citing language in Celotex, which is the basis for Rule 56, which is the basis for Rule 1.510 being amended. And in that case, citing Rule 56, it talks about affirmative proof is not required by the movement. But it does also talk about that it is required that there be some showing that based on the depositions, based on the pleadings, based on the request for admissions, based on answers to interrogatories, based on depositions, that there be some showing that there's no issue of material fact. So there has to be some showing, but the movement does not have to say, hey, here's some affirmative proof that, this should be granted. So that's the distinction between those. And if we look at the actual language that was retained in 1.510, it clearly talks about.
Well, the court had the record in front of it. You agree with that, right? The interrogatory responses and other.
Did not have interrogatory responses, had notice of serving answers to interrogatories, but not interrogatories.
So you're saying there are no interrogatory responses from front of the court?
No, Your Honor.
Not in the court file?
Nothing was filed by the movement to support its position. And
the appellee cited to a deposition that the court ultimately struck, but the court referred to that deposition in the order, the final judgment, correct?
yes, Your Honor.
And that transcript was not before the court because the court had struck it.
Correct.
And you're indicating that there was no evidence of record before the court, is that correct?
Correct, Your Honor.
And the rule itself, and I've read the opinion that it reconfirms what the rule is going to do, but the rule itself in the first section of 510C1, a party asserting that a fact cannot be or is genuinely disputed must support the assertion by, and then A talks about citing the particular parts of the record. And in Celotex, if I remember correctly, the defendant had actually pointed to interrogatories that failed to identify witnesses that would support the plaintiff's claim. And then B, showing that the materials cited, so again, it's referring to materials that are cited, which under 1 are 1A, you have to support the assertion by citing to the materials. So B says, showing that those materials don't establish the absence or presence of a genuine dispute, or that an adverse party cannot produce admissible evidence to support the fact. The clause I want to focus on is that last part, or that an adverse party cannot produce admissible evidence to support the fact. Assume for the sake of the argument that in fact there has not been no discovery revealing any supporting evidence. Is it your position that the movement has to file that discovery that doesn't show anything in order for the court to rely on or to determine that the movement met its burden? Or is it your position that if the movement is going to talk about, look, they took the deposition and there was no information establishing negligence or negligent hiring, that they have met their burden by pointing that out to the court, but they don't actually have to file the deposition? What's your position on that?
I think the deposition, any of the factual evidence that would support granting summary judgment has to be filed. It has to be before the court.
There's nothing in the evidence, at least according to the city, there's nothing in the evidence that helps establish your client's case.
Correct.
So do they have to introduce or file that non-evidence, documentary evidence in some way, answers to interrogatories, deposition, admissions? Do they have to file those to say, Judge, you have to look through that. We're telling you there's nothing in there. Here's the question, the key questions that were asked on pages so-and-so and so-and-so, lines this and that, and you can take a look and you'll see it's not there. Is that what they're supposed to do?
Yes, Your Honor. They have to have something in front of them. It can't just be a motion saying there's nothing there. This is not a motion to dismiss. It's a motion for summary judgment. It has to be based on facts that have been developed, and it can't just be, hey, they don't have a claim. There has to be something, because ultimately the court, and especially under Rule 1.510, the court has to make findings of fact that summary judgment should be granted. And it's not just conclusory statements. And there was a case that came out of this court late last year that specifically talks, it has to be specific findings of facts. It can't be conclusory statements. And to have that type of information, there has to be some factual evidence before the court. And that deposition was stricken because it was filed way after the motion was filed, 1.510.
I understand why it was stricken. I am troubled by the fact that the court then cites to document a deposition that is not in front of it.
Can I clear up, I have a question about that, the court citing to that document, because my read of the judgment is that the court expressly disclaimed considering the deposition in footnote 1, and I didn't see a reference to the deposition in the body of the judgment, nor did I see it in the court's ruling. And to follow up on that and the rest of what you said, my question about what the judge was required to find in the final judgment, if she found, and this strikes me as being consistent with the rule, but tell me why it isn't, that there was simply a complete failure, a lack of evidence. And in my mind, it's a lot like, as you said, a directed verdict situation where, that's the purpose now, that's one of the reasons we have summary judgment, is to see if you can withstand the directed verdict. And in this scenario, what we're left with is an analog to where, you've put on an argument for a case, but you're going to try to defend against a directed verdict with no evidence, which doesn't make sense to me. It's like you went to trial and the trial court granted a TV for the city because there was, and you told the judge at the hearing that you had some evidence, but that it wasn't your obligation to submit it. So that seems to be a little frustrating around the purpose of the rule as it's been amended.
Well, and it is frustrating. If you go to the standard for direct verdict, what the court has done in this case is essentially, if we're comparing summary judgment to directed verdict, then we're talking about a situation where the trial court entered a directed verdict before the plaintiff even got the chance to present their case. Because it's not my burden at the hearing on the motion for summary judgment.
What's the difference between the burden of production that the city had when it filed its motion or what's the effect of, let's assume that by bringing forth the motion and saying there is no evidence to support this claim, there is no record evidence, which would seem under the case law describing what is the burden of production to fulfill the city's start point, right? Doesn't that shift the burden to you to create an issue, a trial issue of fact?
It would be if the city actually supported it with some factual evidence.
Then you're saying the city has to prove negative.
They don't have to prove a negative, but they have to provide something in support of their motion from which the court can make findings of fact. There is no
Is that not the
material issue
burden
of
of
fact.
persuasion though, as opposed to the burden of production?
Well, it's a burden of proof.
We're not talking about the same thing. The burden of production is the initial burden that the movement is going to carry, even if it doesn't have the burden of persuasion at trial. Burden of persuasion, it follows that. But once it's carried, once the city carried its burden of production, your position is you didn't have to do anything unless the city substantiated it. With evidence, even though you had evidence to controvert the city's position that there was no evidence. Because you told the judge you had evidence to controvert it, but you didn't think you had to do anything with that.
Correct. And the burden of production, is the burden of production filing a motion, or is it filing supporting factual information from which a court can make findings of facts to enter summary judgment or to deny summary judgment? The initial burden is on the movement. And 1.510 still talks about, in subsection A, the court shall grant summary judgment if the movement shows there is no genuine dispute as to any material fact. And then subsection C.
Looking at the opinion, the court relies on the Eighth Circuit's opinion in Bedford and the Fifth Circuit's opinion in Weiss, which suggests that, and I'm just going to quote from the opinion, quoting Auckland, a movement for summary judgment need not set forth evidence when the non-movement bears the burden of persuasion at trial. So how do I reconcile that with what you're telling me?
Well, the Supreme Court considered, and it reevaluated 1.510, and when it did so, number one, it kept in the author's comment from 1967 language that says there must be some evidence. Also in there, the language in subsection C says that must support the assertion by citing to particular materials in the record. Subsection B, which Judge Silverman cited to, showing that the material cited, again, something other than a motion, some record evidence.
I do want to talk about Bedford for a moment because, and by the way, Judge LeBrit's correct. I misspoke. It wasn't in the final judgment, but it was argued at the hearing what the depositions did or didn't show and in the motion that the movement filed. But in Bedford, the court specifically talks about the burdens and so forth. But then it says that the movement must identify the portions of the record that it believes demonstrate the absence of a genuine dispute of material fact. And it seems to me that a reference to the record means what is in the record, not what might be or could be in the record. And so, I'm not sure that Bedford is as supportive of the city's position as the trial court seemed to think it was. Because again, it's referencing identify the portions of the record.
Correct, Your Honor. And that's any summary judgment motion that I've had. The judge always says, please direct me to the portion of the record that supports this argument. And the reason is because 1.510 still, under the new standard, requires that there be some showing of record evidence. Celotex talks about it should be based on answers to interrogatories, requests for admissions, depositions, and any other information. But where the issue becomes is what is required. Is there required affirmative proof? Celotex and Rule 56 would certainly suggest that you don't have to give affirmative proof, such as an affidavit saying, hey, there's nothing here. There has to be something for the court.
A negative, but you have to demonstrate that in the record, there is nothing that supports the plaintiff's claim, is what your position is.
Correct.
And both Celotex and Auckland, or Weiss versus Auckland, use the same language. The moving party may meet its burden to demonstrate the absence of a genuine issue of material fact by pointing out that the record contains no support for the non-moving party. And I think that your whole case on appeal turns on that language versus the rule, which says, and this is the last part of the section I read earlier, C1B, showing the materials do not establish the absence or presence of a genuine dispute or that an adverse party cannot produce admissible evidence to support the fact. And I think it's that last clause that we are struggling with, because if you read that out of context, all the city has to do is come into court and say, we're moving for summary judgment, there's nothing out there that could possibly support the plaintiff's claim, and then the plaintiff has to come forward with documents to show the city is wrong, which, one of the practical concerns I have is the city may not want to spend the money to get a transcript of this deposition that they're referring to. And now the burden is on the plaintiff. Well, you go ahead and pay for the transcript and show the court that, in fact, evidence is in there.
Well, two things, Your Honor.
Counsel, just, we're into your 15th minute.
Okay.
I'll let you go ahead and answer that question.
Sure.
And then if you want to reserve 5 or 3, then let me know what you want to do.
Okay, I'll reserve 3. So to answer that question briefly, the issue still requires, and let me back up for a minute. If we look at that one little section of C1B, the second half of it, and read that in isolation of the whole thing, I could certainly understand that comprehension of the rule. But we have to look at the entire rule. We have to look at the intent of the rule. And if we look at what the entire rule says, it says that movement shows there's no genuine dispute as to material fact. There has to be some fact. There's no facts that were presented by the city. There was no facts for the court to consider. And the entire order granting judgment for the city cites a bunch of facts that were not before the court. So when summary judgment is granted, there has to be some factual basis. It's not a motion to dismiss that says, hey, this pleading just isn't supported. And you can't just have a motion that says, hey, their position is not supported. There has to be something. And it's not proving a negative. It's saying, hey, here's all the evidence that we have, and it's not supported in this case. And I'll reserve the rest of the time.
You'll have 4 minutes left.
Thank you.
Good morning.
Good morning.
Please the board, Ursula Richardson. Oh, sorry. Ursula
Counsel, you may want to pull the mic down and close you a little bit.
Ursula Richardson with the City Attorney's Office for the City of Tampa. I think the question here is, when we boil down what was actually in the complaint and what plaintiff conceded was really the issue here, is the negligent training claim is all that's at issue here on appeal, because the supervision.
I thought it was the negligence of firing to the crowd that was the ultimate issue.
The complaint actually talks about negligent training an officer to use the weapon that's at issue in this particular case. And so that's what they're saying caused the officer to fire the way that he did into the crowd is the training. And so from the perspective of the city's motion for summary judgment, we focused on what you have to prove in a negligent training claim. And here in this particular case, the only discovery that happened was the exchange of written discovery. The record requests for productions are within the record itself.
Was the material produced that you're relying on filed with the court?
I guess I could have filed it, but there's
That's not
nothing,
my question. Were they filed?
the interrogatories.
Were the documents that your client, the city, wanted to argue to the court, look, here's all this information, they don't have anything. There is a manual that shows the training, here it is, it's perfectly fine. That was not filed, correct?
No, sir, and I don't believe that's the city's
Interrogatories were not
obligation.
filed either, were they?
I'm sorry.
Answers to interrogatories were not filed.
No, sir.
I mean, I think I know the answer, so let's cut to the chase on it. Was anything of record that was used in support of the motion for summary judgment?
Other than the deposition, which was inadvertently not filed, but other than that,
By the court, so we can't, you argue throughout your brief, which is concerning to me, language from the deposition, that the court said it was not only not considering, but the court struck. So that's outside the record. So we're not going to talk about what's in or isn't in the deposition,
Okay.
correct?
yes, Your Honor, but from the perspective of what the elements are, and because the elements here are duty, breach, causation, and damages. What witness or what piece of evidence have been brought before or in the record or before a jury? If we just look at this as a directed verdict, the plaintiff had filed
The
his,
directed verdict is after submission of evidence by the plaintiff. And
correct,
so the question I think becomes, and we've fleshed it out with the appellant, does the city, in seeking summary judgment, have to do anything of an evidentiary nature? Or like a directed verdict, the burden is automatically on the plaintiff, the appellant here, to come forward with this evidence. And the reason that I'm focusing on the rule and some of the case law, it sounds like the city's position is any party, any defendant can come into court and say, there's nothing out there that they can use to prove their case, and now that's enough to shift the burden. That seems to be what you're saying.
It is the city's position that when you basically take the document, the complaint, what is the theory here? What are the elements? What happened during discovery, which was laid out here?
But
What-
the discovery is not of record.
Even if it had been, again, you can
Well,
file
it's
it.
not- It doesn't matter if it could have been or should have been, it wasn't. So my question, again, I'll repeat, is there any burden on the city or on a party seeking summary judgment? Is there any burden on a non-movement to provide anything for the court to review in support of the motion? Or is it simply enough to say, truthfully or not, there is nothing that the plaintiff has found that's going to support their case? Judge, make them show you what they're going to be able to do. Is that all that's required for summary judgment?
It's enough to talk about what happened during the course of discovery and say that none of those things
But
support
isn't
it.
the court supposed to be able to review that and make factual findings that city is absolutely right? The officer didn't testify. In fact, this officer, not in this case, but hypothetically, this officer said he wasn't even on the scene. They're suing the wrong person because the officer said he wasn't there. They haven't filed anything in response to show that he was there. So it sounds to me like the court has to have something before it to
But-
make a determination of fact or absence of fact to support summary judgment.
And I'm not really certain how you support what's not there. I'm not actually certain how you do that.
Okay, so I've been listening and I'm trying to understand what the argument is. Are you suggesting that the court could have taken a look at the record to see that there was nothing in the discovery that was done or requested such that would be fruitful for their claims?
Yes, Your Honor, and
Is that your argument?
yes, Your Honor, as I understand it, the interrogatories weren't filed, but the requests for production were. Since we're focusing on the city's training, I pointed out to the court that no training materials were turned over, so I don't know how I prove the negative. They asked for the materials, there was an objection to the materials.
And they
No-
didn't follow up with.
and they didn't
discovery
follow
or
up,
what
so-
they were about.
If we're strictly focused on training, I don't know how we get from duty to breach to causation to damages without the connection between those things, which is there was no information cultivated in the record or during discovery that could say what the city's training was, how it failed. And I don't know how any jury could come to the conclusion just based on the officer's testimony, the chief of police's testimony, and the plaintiff's testimony, that there was a failure of the city's training program.
So your point is then how are we supposed to point to any record evidence when it wasn't even developed? And why should the burden be on the city to develop that evidence?
And at the moment that we're at the hearing and the court is saying, well, just point me to it, the only thing that had been filed after the summary judgment was the deposition that was stricken and a newspaper article about this particular event, and that's it. So there was nothing from which the court could say, even the expert was only briefly alluded to, but no information about what this expert could say. And as we now know from the affidavit, that expert himself doesn't even know anything about the city's training program. So I just don't know how we prove the absence of any piece of evidence or any piece of testimony that could possibly be put before a jury such that they could come
Well,
to
I
the
mean,
conclusion.
the city could have had a supporting affidavit filed with their motion for summary judgment about the city's training. I mean, there are ways that the city could have pointed to some sort of evidence that could have been in an affidavit, even though it wasn't a deposition. But, I mean, I think the city was in a predicament with the deposition being stricken. I mean, because people were relying on that deposition initially.
I'm not certain, yes, that could have happened, but I'm not certain how explaining
Well,
to
you
the
would have been able to satisfy, if we find that you have to put forth some sort of evidence, you would have been able to satisfy that requirement by there being a deposition. And there were
Correct.
things in the deposition that pointed to matters that plaintiff could not have proven their case in based on the deposition of the officer.
But with the court striking the officer's deposition, which only had like a minimal passing reference to the training, there would be nothing in the court record.
What's the reference to the training in the deposition?
Correct, that he was
But
trained.
we don't know what that was, and the court doesn't know what that was. They're taking your word as a lawyer that it didn't address the issue that they have to prove, right?
You're taking, I'm sorry,
You're telling us, as you told the trial court, that there's a small, you said now, but there's a very small portion in the deposition that addressed training. We don't know if that small portion supports the appellant's case or supports the city's case. And I also want to point out, and then I'll have Judge LaBritte ask the question she wants to ask, but you said in the status of proceedings in your motion, something different than I think you said now, maybe I misheard you. During the discovery period, written discovery was exchanged and plaintiff deposed Officer Stanjeski and Chief Dugan. So apparently there was discovery that was exchanged, where I think you had said earlier there wasn't things produced, but there was some written discovery that was exchanged. Let me finish.
okay.
And then you say the moving party's burden may be discharged by showing the trial court that there is an absence of evidence to support the non-moving party's case. And you were telling us that the deposition and the materials that were apparently exchanged do not help the plaintiff prove its case. But those materials aren't in the record. And by the way, if we were to reverse, and I don't know that we will, but hypothetically, if we were to reverse, there's nothing that prevents either party from again seeking summary judgment, right? There's no bar on that.
I guess if you were to remand with instructions to, I guess, start again, because we were at the trial
Further
stage.
proceedings, and that would not prevent the city from saying, oh, here's all this information. We told you about it. Yeah, we didn't file it. Sorry, but here it is. And obviously, now the other side has an affidavit. I don't know what the affidavit says. Don't really care because the court didn't consider it unless we determined that the court should have. But that's neither here nor there now. But anyway, that's not a question. So let me turn it back to Judge LaBritte.
I just wanted to make sure I sort of understood in a nutshell what your position is. And if I'm hearing you correctly and understanding your argument, I think what you're maintaining is that you discharged your burden as the defendant moving by making sort of a blanket, and obviously you started out with the officer's depot, but taking that out, your position without that is, my argument was that no evidence had been developed in the discovery. So I didn't have to show you what the non-information was. And by saying that, I pushed the burden over to the plaintiff to produce some, either point to the record or file something and get it in the record before this hearing that substantiates the allegations of the complaint with respect to the negligent supervision, because that's all that's left, based on the plaintiff's concession at the hearing. Am I correct in that?
The negligent training, but yes, that is the city's position, is that once we point to this is the theory, and once we point to these are the elements, and this is what, essentially there is nothing, then it,
And as Judge Silberman was saying, perhaps the city knew that the deposition had occurred, and I think you cite that in your motion, but maybe it wasn't transcribed because the city didn't think it added up to anything and wanted to push the onus to the plaintiff, that if you're gonna rely on that deposition to prove that part of this claim, put it out here and let the judge see whether it creates a triable issue. Is that where you were with this?
correct, the deposition of Officer Stanjeski was ordered, but in this case, the deposition of Chief Dugan was not, because it didn't yield any particular information that would have been helpful to anybody, and which is why it's not cited. It's not particularly cited in the motion because it was not ordered. But in the instance that the question was being asked earlier, if no written discovery had been exchanged, and if no depositions had been taken of any party, it would be the exact same position that the city would be in is, hell, judge, this is what they alleged. These are the elements they have to prove, and what facts.
That's a different scenario though, because then the record would establish that there have been no interrogatories sent out, no requests for production, no motions to compel, no depositions scheduled. So there'd be something in the record to say, there ain't anything. Here, we know things have happened because you said it in your motion. And so my concern is, how do we get around the Celotex language and the other cases that talk about the movant who has no burden at trial can point to evidence of record, because that's what it seems to be talking about. And here, I mean, I agree, you don't have to come forward with any new evidence. You don't have to come forward with an affidavit, but if you're relying to say, we've had discovery and the discovery doesn't help them, it seems to me the rule and the cases seem to be saying that you have to have those in the record so the court can look at them. Now, again, I know there's at least one case that I came across which the wording doesn't seem to be quite the way I said it. They just say, doesn't have to come forward with evidence. And so I agree, you don't have an evidentiary burden to prove the negative, but I'm concerned that you might have an evidentiary burden or a burden to show, here's what's happened so far in the case, and there is nothing here that they have been able to generate by taking the officer's deposition or the police chief's deposition or the documents. Here they are, and nothing supports their theory. And then the burden does shift at that point. I mean, if you can tell me I'm wrong, I'm not going to be offended by that. I'm just trying to find legal support for this argument that all a party has to do, all a movement has to do is come into court and say, Judge, there's lots of stuff that's happened, but none of it helps their case. Make them show you what helps their case.
Well, and the court tried to do that at the hearing, which is they had an opportunity. The rule gives them an opportunity to respond in opposition. And although we've been talking about what evidence they may have, to this day, we haven't heard of any.
I agree. They did not do anything on a timely basis to show that your position was wrong. So it goes back to the question of, does the movement's burden include not simply saying things have happened in the case, but they're not helpful to them? Or is the movement's burden to say things have happened in this case, hasn't been helpful to them in any way, and Judge, here they are in the record, that's what we're relying on, is the discovery, the production, the answers to interrogatories, depositions, whatever, admissions, and they don't show anything that helps them, and then they come in and say, well, we think there's enough here, and here's why, or they come in with an affidavit, which in this case, they came in late with an affidavit. So my focus is really a very narrow one, which I think is what the Celotex case and the rules try to address. What is a movement's burden when the movement doesn't have a burden at trial for summary judgment?
I don't know what the answer to that question is, other than to say that I guess a more thorough way of proving the absence, a more thorough way of proving it is, here's everything that happened, and just tell the court it doesn't fit the complaint or the theory. However, I believe the motion was sufficient to tell the court that, to point the court.
I will concede, if the deposition was of record, the motion could very well have been sufficient, because then they can say the deposition has this information and it's helpful, or they say they're right, the deposition doesn't have anything, but here's some other information that shows we do. And so it seems to me the city understood its burden because it was referring to these other materials, but then didn't file them timely. And so, that's where I'm having some difficulty with this. Again, relying on the language and Celotex in the other cases. I'm done with my questions because I think I have beat to death what I'm concerned about, but Judges Britt and Smith might have more that they want to ask.
I don't have anything further if all the questions are answered. We would ask that you affirm Judge Moe's order in this particular case, finding that there was an absence of record evidence to support the plaintiff's claims and theories that they would have had the burden for at trial in this particular case. Thank you.
Thank you so much. Counsel, you've heard our questions, there may be some more, but the bottom line is, I understand your argument, and I understand what the cases say, but there's at least one case, I don't remember now which one it was, that had some wording that wasn't quite following the language in self-test. So why would it be wrong for us to interpret this case the way the city is arguing that, look, we pointed out the absence of any record evidence, and we don't have to come forward with that. You're on notice that we don't think there's anything there. You need to come forward. Why is that not a reasonable approach?
That's not a reasonable approach because it has to be based on facts. If the court has no facts in front of it, the court can make no factual findings, which is what is required. If we look at the language of the current rule,
Counsel, it strikes me that one of the statements that the Supreme Court made in the amendments opinion is indicative of your circumstances. And the court was citing a treatise, but the opinion says, in Florida, it will no longer be plausible to maintain that the existence of any emphasized competent evidence creating an issue of fact, however credible or incredible, substantial or trivial, stops the inquiry and concludes the summary judgment so long as the slightest doubt is raised. This is in the discussion about what the burdens are. And it strikes me that, you'd be a lot better off if it was still plausible to make the argument that was available before 1.510 was amended.
I would agree with that, Your Honor. I mean, 1.510 created a higher burden for the non-movement once the movement has established its burden. The movement still has a burden to show the facts in the record do not support the non-movement's claim. There's still a requirement of showing, and Judge Silberman was talking about the language of the
The court also said on the same page, a movement for summary judgment need not set forth evidence when the non-movement bears the burden of persuasion at trial, and you are the plaintiff, so you bear the burden of persuasion at trial.
Correct, and if we...
I'm struggling with why the city would have a burden under what the Supreme Court instructed us, this rule means it amounts to get fined.
Right, and if we look at the language of Rule 56, federal rule, which is what this is based on, the language is that it was intended to duplicate Rule 56 essentially. If we look at that and we look at the Celotex language, it talks about that a movement does not have to bring forward new evidence or affirmative evidence. But it still talks about the judge should be considering based on the depositions.
It says the movement need not set forth evidence when the
Correct.
non-movement bears the burden of persuasion. What does that mean? If it doesn't mean, the movement isn't required to set forth evidence.
If we read it in the context of the Celotex case in Rule 56, which it was based on, then it's requiring that there be some showing of the evidence that's been cultivated. Not that there has to be a showing of new evidence saying, hey, here's this affidavit disproving.
Was that you hadn't cultivated the evidence.
Sure. But if the court is making findings of fact, there has to be facts in front of it.
And you accuse the court of making findings of fact in the judgment, but it seems to me that what the court found was that there simply was no record evidence to substantiate the claims alleged in the complaint. And the rule didn't require her to make findings of fact. It says the court will state on the record the reasons for granting or denying the motion. It says nothing about fact findings, and she didn't make any fact findings.
And she did not make any fact findings that were supportive of the initial verdict.
She didn't make any fact findings at all. She found that there wasn't evidence.
Well, she referenced a number of different things that allegedly disproved plaintiff's claim, but never referenced any factual support, any fact at all that showed that the movement met its burden. There's nothing in the order granting summary judgment.
Real conclusion that the movement had its burden since it didn't rely on any evidence, and the Supreme Court's opinion clearly states that the movement can make this motion without citing written the opinion away, but I think it says bring forth evidence.
Oh, respectfully, Your Honor, I disagree with the interpretation of the Supreme Court's, changing of the rule, the language in that. If we're looking at the intent of the Supreme Court intended to rely on the Celotex case and Rule 56 to be the basis of that. And to the extent that no new affirmative evidence is required, I would agree with that. There still has to be something to show. And I would submit the Florida Gulf Coast Chapter Associated Builders and Contractors versus City of St. Petersburg. This was decided in December of last year by this court.
Is it cited in your brief?
Pardon?
Is it cited in your brief?
Yes, Your Honor. And specifically, the recent case law says that statements on the record of the reasons based on facts.
And that's what the trial court did here. I mean, it went at length and discussed how the plaintiff has not brought forward any evidence that would support their claims. And then the court went on to say there's an absence of any record evidence in the file that would allow me to conclude that these claims have factual support. There's nothing from which a jury could determine what the city's hiring process was and how it failed. And it goes on. So I don't know how you can say that it was a lack of any, well, I know your argument is findings, the rule doesn't say findings, but reasoning is what we're looking at. And as you just cited to the Florida Gulf Coast, that's what we said. We said reasons.
And reasons.
You can answer that. Your time is basically up. Go ahead and answer that.
Sure.
You have 30 seconds.
Right, and I agree the language is reasons. What would be the reasons that a court would grant summary judgment? The facts do not support it. There are no facts in this case. There are no facts that were asserted. Well, there are no facts that were filed and from which the court can consider that there was factual support for the movement's position. Therefore, it should have been denied, and it was not. There was no factual evidence before the court. And the order should be reversed and remanded.
Very good. Thank you both very much. We will have our panel switch and go to the break exit.
Thank you, Your Honor.
Thank you both. And counsel, for the next case, if you want to go ahead and get situated, is Anderson versus State.